Hill Boren et al. Versus Hill Boren PC et al.
Good afternoon. All right, I believe everyone that's been here before. After the appellate comes to the podium, if you'll introduce yourself and then let us know how much time you'd like for rebuttal. We're here from the appellant.
Good afternoon, Your Honors. My name is Tamara Hill for the defendants Hill and Hill Boren PC. I would like to reserve 3 minutes.
3 minutes for rebuttal.
Yes, Your
All right.
Honor.
Thank you. No.
Let me get some water.
Sure.
Okay, here we go. May it please the court. I'm Tamara Hill, attorney for defendants Hill Boren and Hill Boren PC. Defendants rely on their brief and their reply brief, but also wish to add the following. Respectfully, to affirm any part of the judgment in this case would be to wreak havoc on Tennessee businesses and their owners, as numerous Tennessee Supreme Court precedents and well-established Court of Appeals decisions would be reversed. First, parties would now be able to both enforce an executory contract and maintain an action for promissory fraud. Under Kelly, the court must look at the document itself. It will find that the agreement for future transfer was, as its name implies, to be performed in the future, making it an executory contract. 2, consideration will not be required and conditions may be ignored. Again, under Kelly, the court will find no reimbursement if Boren had died prior to time for performance, a condition precedent that Boren did not meet prior to filing his complaint, and that the consideration is found in the whereas clauses. 3, justifiable reliance will no longer be required to maintain an action for promissory fraud. Neither plaintiff testified that they trusted Hill. Boyd testified that he predicted that Hill would not follow through and warned Boren of the same prior to either signing it. 4, currently, promissory fraud has not been adopted by the Tennessee Supreme Court as a cause of action. Rather, it is considered a defense to a breach of contract claim. This makes sense. An award for damages for being fraudulently induced to sign a contract that plaintiffs want enforced is inconsistent, both legally and factually. 5, parole evidence will be freely admissible to alter the terms of a written contract because seminars will advise all attorneys to claim promissory fraud in all contract cases to get around the parole evidence rule. Plaintiffs never intended to leave, but counsel argued that they were leaving so that staying became the alleged basis for the promissory fraud claim. And Boren did not want to honor his responsibilities under the agreement. He wanted to enforce unwritten negotiations, but both admit that they did not rely on any promises outside the written agreement and that they each knew what it contained when they signed it. 5, arbitration clauses in employment contracts will be rendered unenforceable. This arbitration clause is in the attorney contracts, not the client contract with the firm, so interstate commerce does not apply. Second, the arbitration clause actually provides a method to determine liquidated damages in the event an attorney leaves and takes the firm's clients with him. Having availed themselves of the benefits of their respective employment contracts, signed or not, plaintiffs also are bound by the requirements of those contracts. 7, a party will now be entitled to profit more if a contract is breached than if it is fulfilled. Plaintiffs profited far more than they expected from the aft as a result of the alleged advertising breach. Rather, by accelerating advertising when the laws changed and spending more in total than projected, the firm brought in over $8 million in gross fees for the plaintiffs alone and over $48 million for the firm, rather than the $2.5 million that plaintiffs' experts said they expected. A jury award cannot be justified. Number 8, a fiduciary's choice not to disclose will no longer be considered fraud, for he will not even have a duty to disclose. Number 9, a corporate officer may now compete with his corporation prior to resignation and seize its business opportunities, not just prepare, but actually compete. Written waivers by sophisticated parties will no longer be enforceable. Number 11, filing and maintenance requirements, as well as standing to bring derivative actions, will be abolished. Number 12, temporary injunctions will no longer require material evidence or be required to maintain the status quo. 13, corporate bylaws will no longer be enforceable. 14, specific performance will now be available in the presence of contract ambiguity, allegations of fraud, and awards of damages for breach. 15, specific performance will not have to be equitable or just, and it may be awarded where the plaintiffs are made whole by monetary damages. First, the trial court awarded specific performance on top of plaintiffs' admitted $5.5 million in excess gross revenue and a $4 million jury verdict. That is neither equitable nor just. 16, arguments of counsel that contradict their own client's testimony will now be accepted as material evidence. Numerous trial court orders are based on attorney arguments in briefs or at trial. Most glaringly, after the trial, wherein plaintiffs both admitted under oath that each was paid everything to which he was entitled, roughly $2.5 million to Boren and $2 million to Boyd. Trial counsel urged the civil trial court to find Hill guilty of the crime of theft of services, and it did so. 17, sophisticated parties complaining solely of economic loss will no longer be subject to Tennessee's economic loss doctrine, and third-party beneficiaries will now be able to recover damages outside the terms and conditions of the contract. Plaintiff's basic position is that they have economic loss because over $4.5 million for the work that they did between 2013 and 2016, and $4 million more prior to the trial wasn't enough, even though they only expected to get $2.5 million for the entire firm. Plus, they deserve extra money to advertise their new firm because all of the advertising for the old firm was really just supposed to be for them, not anyone else in the firm. 18, proof to support an award of punitive damages will not be required in the second phase of a bifurcated trial anymore. 19, the business judgment rule will be eliminated. 20, ex parte communication with the jury by the court during the trial will become permissible without checks and balances. 21, courts may now rewrite contracts as they see fit. 22, attorneys may be sanctioned for providing sworn, documented evidence that a verdict was obtained by fraud. 23, parties will now be able to write orders without supporting the transcript to add or delete facts and findings to shape their narrative, have the court sign them, and then present those orders as evidence on an appeal, just as plaintiffs have done in this case. 24, a party may contradict his own testimony without explanation, yet his helpful testimony will be considered and his unhelpful testimony or contradictory statements disregarded. 25, unclean hands will not bar plaintiffs from seeking an equitable remedy, but it will bar defendants who are not. 26, Rule of Evidence 408 will be abolished as settlement negotiations were admitted and formed the basis of plaintiff's claim. This court has a duty, and indeed the power, to correct these errors and multiple avenues by which to accomplish that task. First, this court should declare the judgment void in all respects based on either number 1, lack of subject matter jurisdiction, as pled in the answer and the amended answer. 2, obtaining the judgment by fraud, as set out in the brief. Or 3, noncompliance with the rules. First, Flax was a products liability case with statutory pleading requirements. This case is governed by the Tennessee Rules of Civil Procedure, 801, 902, 903, and 2306. Plaintiffs failed to comply with these rules, rendering the judgment void. Second, plaintiff's reliance on dicta in Flax is misplaced. Neither void judgment, ad damnum, nor waiver was truly before the Flax court, and any comment on those areas is nothing but dicta. The fact that a judgment is void cannot be waived. The burden for plaintiffs pleading compliance should not be shifted to defendants. This is a common refrain with these plaintiffs. Defendants should make us follow the rules. Second, the rules of civil procedure must be interpreted in the same manner as statute. And this is a big issue. As set out in the brief, this honorable court should exercise its duty under Watts, Rye, and Hanover to make long overdue correction to the interpretation of Rule 50.02. Regardless, because Defendant Hill was barred from representing himself or the corporation he founded, and because trial counsel was, as plaintiffs repeatedly point out in their brief, ineffective, this appeal should be considered on the merits rather than a technicality. Third, under Barra, Caldwell, Helms, and Witzel, the verdict must be reversed on the issues of fraudulent inducement, breach of contract, derivative action, and punitive damages, because, as set out in the brief, the jury instructions were faulty and deficient. In closing, defendants would also urge this court to strike plaintiff's brief, because 1, it relies on trial court orders and allegations in their own pleadings, neither of which are evidence, and 2, it cites, often inaccurately, to large sections of the record, asking this court to hunt through the record to build their case for them. Defendants further urge this honorable court to grant the relief sought in the written admissions. Are there any questions? I will try to answer them.
Seeing none, thank you.
Thank you, Your Honor.
We'll hear from you on rebuttal. Now for the appellees.
Members of the panel, if it please the court, my name is Teresa Luna, and I represent Ricky Boren and Jeff Boyd. By our count, T. Robert Hill and Hillborn PC have appealed 53 issues. 41 of those issues have been waived or they're unreviewable by the court. But before I begin addressing the remaining issues, I'd like to bring up a very important point. Mr. Hill is no longer a director of Hillborn PC. He's no longer a majority shareholder of Hillborn PC. In August of 2019, the court issued its judgment. In that judgment, it declared that shares of stock from Robert Hill would be transferred to Ricky Boren and Jeff Boyd, thus giving Ricky Boren controlling interest in the stock. Mr. Hill had an opportunity after that to use the stay provisions in Rule 62 to stay the transfer of these stocks. He chose not to do that, so therefore, the next month, the court transferred the stocks to Ricky Boren and Jeff Boyd, giving Ricky Boren controlling interest. Soon thereafter, Mr. Hill was removed as a director, he was removed as an officer of Hillborn, and he was removed as its counsel as well. There's a Tennessee Supreme Court case that's important here. It's Keller versus the state of McRedmond. And in that case, it tells us that the only person that can bring a lawsuit or an appeal on behalf of a corporation is the corporation itself, acting through its directors or the majority of its shareholders. Well, Mr. Hill is not a director and he's not a majority shareholder, but yet he's the one who brought this appeal after he was removed from those positions. So therefore, of the issues that are remaining, 3 of those remaining issues are brought by Hillborn PC and they're not properly before the court. I do want to address Ms. Hill's argument on the motion to void the judgment first before I begin with the other issues. There are 4 reasons why this court should deny that motion. The first one, there's a case directly on point, and as Ms. Hill pointed out, it's Flax v. Daimler Chrysler. It's a Tennessee Court of Appeals case from 2006, but it was upheld by the Tennessee Supreme Court, and specifically in that Supreme Court order was the notation in the brief itself, in the order itself, that it upholds the finding that Rule 1208 bars the complaint about an addendum clause after the trial is over. Second reason, Rule 1502 of the Tennessee Rules of Civil Procedure reads, "Issues not raised by pleadings that are tried by express or implied consent shall be treated as if they were in the pleadings." And as we pointed out in our response to the motion, the issue of damages was litigated heavily for 3 years before the trial. It was in the discovery. It was talked about in the depositions. It was discussed in the pre-trial conference. The defendants submitted proposed jury instructions on damages. When we were at the trial, the defendants questioned our experts on damages very carefully. They questioned Mr. Boren on damages. They questioned Mr. Boyd. They never brought up in any of their motions to dismiss, motions for summary judgment, motions in limine, pre-trial motions, post-trial motions, or appeals, they never brought up this issue of a void judgment. All they had to do was to question what they call the inadequacy of the addendum clause in their answer. That's what Flax v. Daimler-Chrysler requires, that if you think that there is a problem with the addendum clause, then you're required to bring it up in your answer, or you have waived the issue. The third reason why you should deny that motion is under Rule 5403. That rule says that except in default judgments, which we don't have here, every final judgment shall grant the relief to the party in whose favor it was rendered, even if it's not in the pleadings. That rule also goes on to say that if it was litigated and if the other party had an opportunity to be heard. Well, of course, every party had an opportunity to be heard here. The final reason falls under Rule 60.02, and that was the vehicle that Mr. Hill used to bring his motion to void the judgment. The problem with Rule 60.02 from Mr. Hill is that it's not a void judgment unless it meets one of these three criteria. The first one, when there's no general jurisdiction of the subject matter, and that's not what we're dealing with. The second way is if the decree is wholly outside the pleadings and not tried by consent. Well, this is not wholly outside the pleadings, and it was tried by consent. And the third way is if the person was not before the court, and of course, Mr. Hill was before the court. So we would ask the court to deny that motion. As I stated before, there's 53 issues, 41 have been waived, 3 more were brought by Boren PC by Mr. Hill improperly. That leaves 9 issues. There's one issue that was waived that I would like to bring up with the court before I get into the remaining 9 issues. That issue falls under the topic that Mr. Hill has numbered number 7. Mr. Hill argued, waiver of the right to rescission operates as a waiver of the right to bring a fraud claim. Now, 3 reasons why, even though that's been waived, why the court should deny his appeal on that issue. Hill says that when Boren and Boyd sued for specific performance in their amended complaint, that at that moment they waived their right to sue for fraudulent inducement. The court should have dismissed the claim at that particular point. That's what Mr. Hill argues. The problem with that is that Mr. Hill never made that waiver issue before the trial court. Another problem is that he did not include waiver as an affirmative defense in his answer. A third problem is that the case that he relies upon, which is Graham versus First American National Bank, that particular case is different. And Ms. Hill mentioned executory contract. In that particular case, there was an executory contract, a continuing contract. And in the midst of the contract period, one party found out that he'd been defrauded by the other party. When he found out he'd been defrauded, he elected to continue on with the contract, even though he knew he had been defrauded. The court then ruled that you can't know about the fraud, stay with the contract terms, and then later sue and ask for rescission. That's what that case is. This is different. Mr. Boren and Mr. Boyd, they learned of the fraud at the very end of the contract term, right before Mr. Hill was to transfer the stock to them. And they had completely performed their whole obligation under the contract, and then Mr. Hill announces that he's not going to transfer the stock to them. So Graham doesn't apply, and Mr. Hill has waived the waiver issue. First issue that is not waived, that's before the court, has to do with the January 9th, 2017 order that was issued by the trial court on the injunction issue. This was right at the beginning of the case, and this is what happened. We asked for an injunction, the Boren and Boyd asked for an injunction, and Mr. Hill filed a pleading that said he was agreeable not to dissolve the corporation during the pendency of the case. We came to a hearing on December the 19th of 2016, and in that hearing, the parties came to an agreement as to how the status quo would be maintained. When the judge entered his order on January the 9th of 2017, it was basically a memorialization of what the parties had agreed to. So findings of fact and conclusions of law are not necessary for consent orders, if you will. The next topic is under topic number 7 of Hill's brief. And Mr. Hill filed a motion to amend the complaint 3 months after the 2-week jury trial was over. Now, he asked in his motion to amend the complaint, may I add the defense of statute of limitations to my answer? Well, Rule 1502 tells us that you cannot amend post-trial if it's going to change the outcome of the trial. You can only use Rule 15 if it makes the pleadings conform to the evidence. The issue of statute of limitations was not tried at all by consent or otherwise at that trial in June of 2019. The next issue that hasn't been waived is under topic 8, and it concerns the trial court's findings of facts and conclusions of law in its post-trial order on punitive damages. Now, the accusation here is that the trial court adopted Boren and Boyd's proposed findings of fact and conclusions of law. I think all the court has to do is to look at the proposed findings and facts and conclusions of law and the ones issued by the court to determine that that's not the case. The court made its own decisions and its own deliberations as evidenced by his writing in that order. The fifth issue comes from Hill's topic number 11, and this is a complicated issue, and I'm going to try to untangle the weave here, but this involves evidence from pre-June 5th, 2012. Now, we're not sure from Hill's brief if he's arguing that this pre-June 5th, 2012 evidence should not have been admitted for the purpose of breach of contract, or if it should not have been admitted for the purposes of the fraudulent conveyance claim. Either way, he would be wrong. First, a couple of months before the trial, Mr. Hill submitted a brief to the court and urged the court to allow the contract interpretation issue to go to the jury. And in that urging, he said that parole evidence needed to be heard by the jury so they could determine what the contract meant. So Hill can't now come to this court and say that the trial court should not have admitted that parole evidence on the breach of contract term. The other one has to do with promissory fraud. To prove a promissory fraud claim, a plaintiff has got to show that he was promised something before the signing of the contract. He was promised something with the intent not to perform. So that promise was made to Boren and Boyd pre-June 5th, 2012. So there's no way for a promissory fraud claim to be heard without the evidence of the promise itself. The sixth topic is under Hill's topic number 15, and it concerns the Hill-Boren PC bylaws. There was a ruling and a summary judgment. If I could give a little background, Mr. Hill filed a summary judgment, and the summary judgment was asking the trial court to rule that Ricky Boren was not eligible to own stock anymore. Well, this was Mr. Hill's argument in the motion. Mr. Boren is not eligible to own stock under the Hill-Boren bylaws because he's no longer an employee. The court looked at those November 2016 letters that Mr. Hill had sent to Mr. Boren, telling him, by the end of December, I'm not going to transfer the stocks to you. You're being terminated. You and all the other employees are being terminated from your employment. What the court found in that summary judgment was, by the way, it was denied on disputed facts and the issue went to the jury. But what the court found was that a person cannot fire someone in breach of a contract and then turn around and claim that the bylaws protect him, that Mr. Boren could not own stocks. So that issue has no merit. The next issue has to do with specific performance, which Ms. Hill brought up. It comes under topic 17, and the Hills titled it, Whether the Trial Court Exercised Caprice. And I have to admit that I had to look up what caprice meant, but I learned that it meant an impulsive notion, and as our brief indicates, there was no impulsive notion by the trial court in this specific performance issue. If I could back up and give the court a little bit of background there. Prior to the trial, the parties and the court decided that the word specific performance would not go into the jury verdict form. That if the jury were to award damages for breach of contract, that those damages, if Boren and Boyd chose to have the stocks at the end of the case, that in lieu of the value of the firm, that those would be deducted from the total amount. Let me give you the figures. The jury awarded $713,000 and some odd dollars in breach of contract damages. The parties had already agreed that $35,000 was the value of the stocks. So if you'll look in the court's judgment and order, you'll see that the court took the $713,000 in damages, deducted the value of the stocks from that, and then gave Boren and Boyd the remainder of the damages. So in lieu of the stock value damages, they got the stock instead. So there's no overlap in any of the damages, particularly in these breach of contract damages. The last issue, before my time is up, that I wanted to discuss is the ex parte communication by the judge. The trial court made it very clear in its post-trial order that it had a piece of cake with the jury and that it enjoyed the cake, but no facts or no issues were discussed, and Mr. Hill has not alleged any type of specific prejudice that came from that piece of cake. If the court has nothing else, I appreciate the court's time.
Thank you, Ms. Luna. Ms. Hill, we'll hear from you in rebuttal.
The first issue I would like to address is that Mr. Hill can't represent Hill Boren PC in this appeal. Well, I think Ms. Luna makes my point that Mr. Boren couldn't file the derivative claim in the first place because he didn't work for Hill Boren anymore. But nevertheless, the entire issue of the stock transfer is before the court. If the corporation, the owner of the corporation, can't appeal a decision to give the corporation to someone else, then what good is an appeal? Anyway, I'm sorry, I got distracted. Again, Ms. Lynn has pointed out lots of things that were ineffective assistance of counsel. So again, she's made her case for us that we did have ineffective assistance of counsel, and it was egregious enough to warrant us being able to have an appeal. A couple other things. She mentioned the January 9th order. We cited to the December 20th, 2016 transcript. Boren and Boyd were leaving. There was nothing the court could do about it. The court said he could not make them stay. Their counsel said, you're exactly right, you can't make us stay. So there wasn't an agreement for them to leave. They were going to do it, and nobody was going to stop them. So there was not an agreed order. And the last time around, they actually admitted that in their brief. The parole evidence, we pointed out in our briefs multiple objections that our counsel made to parole evidence. And again, if they agreed to something that we are unaware of, that's just another example of an ineffective assistance of counsel on our behalf. Boren also swore, both in affidavit and then was impeached under oath during the trial, that the promises that Hill made him were in 2015 and 2016, which could not, by any calendar of anyone's imagination, have occurred before the contract was signed in 2012. So they could not have been promises that caused Mr. Boren to sign the contract. Again, they talk about the November 21st letters. Those were negotiations, and they are supposed to be excluded under Rule 408, but they've relied on those in derogation of 408. And I don't have the definition in front of me, but that was not the definition of caprice. But basically what I hear council saying is, so they gave up $35,000 to get $2 million, so that makes it fair. That makes it equitable, and that makes it just. And I've run out of time. I would just say that they made conscious choices not to comply with the rules. They know that you can't get more than you plead for, so they chose not to plead for anything, so they wouldn't be limited.
Thank you, Ms. Hill. The case is submitted. We'll now take a brief recess before we hear the final two cases of the docket. Ms. Dempsey.
All rise.